As you may well know, hearsay evidence, they are not admissible in court. There are so many reasons for the non-admissibility of hearsay evidence. But what is hearsay evidence? Section 37 of the Evidence Act provides that a hearsay evidence is any statement, whether oral or written, made by a person who is not the maker of the statement. So any statement in court made by a witness who never made that statement could be termed hearsay evidence, because a maker of a statement has to be present in court to testify so that the other party can cross-examine the witness who is making those statements. Now, and that you find in section 37 of the Evidence Act. And there are so many reasons for the non-admissibility of hearsay evidence, but primarily it would be so that the court can do or conduct a fair trial. All right, so let's proceed to the exceptions, because usually in law, to every rule there are exceptions. So what are the exceptions to the admissibility of hearsay evidence? There are so many exceptions, but today let's treat one of the exceptions. Well, if you've not subscribed to this channel, this is another opportunity for you to do so. Subscribe to this channel and please click on the notification button so that you can continue, or you can be the first to receive any content that drops on this channel. Now, what are the exceptions? Section 40 of the Evidence Act provides one of the exceptions, and which is a dying declaration. What is a dying declaration? A dying declaration is a statement, whether oral or written, made by a person who is in real danger of imminent death. So the person reasonably believes that he or she was going to die at the time he or she made that statement. That could be admitted in court. But there are some conditions to the admissibility of the dying declaration. Number one, the party who intends to tender the dying declaration, usually the prosecution, must show to the court that the person who made the statement is no more. Well, that is a given, right? Because it is a dying declaration. Secondly, the party who intends to tender the dying declaration must show that the person who made the statement was at an imminent, foreseeable danger of death. The person reasonably believes that he or she was going to die when he or she made that statement. Furthermore, the party who intends to tender the dying declaration must show to the court that the statement intended to be tendered is relevant and admissible in court. And then the party who also intends to tender the dying declaration must show that the cause of death of the maker is an issue in that particular trial. See you next time.